Good morning, everyone. Welcome back. I've had my dates screwed up all week. I mean, I knew I got it screwed up on Monday, I think it was, but yesterday I was off a day. Wednesday I was off a day. So today I'm going to get it right. Today is Friday, January 23rd, 2026. I can't believe that. I'm so embarrassed. But anyway, I hope everybody's doing good. I hope everybody's ready for the weekend. It is freezing cold here in California. Very, 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 very foggy. Um, but yeah, I'm happy to be here. I just got home from work, just walked my dog, and I thought, well, before I go to bed, I want to check and see if there's any, responses to Aaron Spencer's motion for judicial recusal. And there is. In fact, I believe the defense responded to the judge's or the court's response. And I believe the prosecution also responded to the defense's motion. So, yeah, let's get into it. I did see on Defense Diaries this morning they were like 15 minutes away from the court when I was watching them this morning on my way home from work. Actually, I wasn't watching them on my way home from work because I was driving. I wouldn't do that. But yeah, they were like 15 minutes away from the courthouse. So they are definitely boots on the ground, and I'm glad that Aaron Spencer will have some of us there to support him and show him that he's not alone in this. And, we're here to fight with him and for him, and we're here to get the word out about what's going on down there in Arkansas, in Lone Oak County, with Judge Barbara Elmore. She's playing word games in these motions, and it's disgusting. I can't wait for you fine folk to vote her out this year. I sure hope you do it because I'm telling you, she's no good for you. She's just not. Okay, so let's get right into it, shall we? Just a recap for those of you who might not know who Aaron Spencer is. Aaron Spencer is an Army veteran who lives on a small farm in Lone Oak County, Arkansas, with his wife and his daughter, who was at 13 when this first started, and she's now 14. He is being charged with second-degree murder for the killing of Michael Fossler, a 67-year-old pedophile, who is an ex-police officer, ex-police chief from Indiana, actually, where he has history of the same type of behaviors. Yeah, Aaron Spencer found out from a family friend that this Michael Fossler, who was also a friend of this family friend or boyfriend or whatever, was they suspected him to be having relations or some kind of nefarious type interaction with Aaron Spencer's 13-year-old daughter. So Aaron Spencer confronts his daughter. She tells him, she comes clean and tells him everything. Aaron Spencer decides to do the right thing and call the police and go the legal route, which why wouldn't he? You want to have faith in the legal system in which you reside, or any legal system for that matter, right? So he reports it to the police. The police take a report. The police interview his daughter and they interview the family friend. Anyway, they end up arresting Michael Fossler and he's charged with, wait a minute, wait for it, 43 felony counts. 43, including but limited to grooming, child SA, child rape, I don't even know what else, but he is arrested and charged with 43 felony counts. Barbara Elmore, Judge Barbara Elmore, yes, the same Judge Elmore that is presiding over Aaron Spencer's trial, let Michael Fossler out on $50,000 bail, which means he only has to come up with $5,000, and he walks and he's out with no restrictions, except he was told to stay away from Aaron Spencer's daughter. That's it. No supervision, no check-ins with the parole officer or the probation officer or whoever. Nothing. No GPS monitor. Nothing. Okay? So where does he go? He goes right back to what he was doing. Picks up where he never lost a beat. Picks up right where he left off. And on October 8th, 2024, in the middle of the night around 1 a.m., Aaron Spencer's wife wakes him up and says that their daughter's chihuahua is barking in their daughter's room. Can you go check on her and see if she's okay? So Aaron gets up, checks her room, thought she was in bed until he pulled the covers back and realized that it was a stuffed animal with her sweatshirt pulled over it to make it look as if she was in bed. Of course, panic runs through him. He's just panic-stricken. On his way out the door to go look for her, he tells his wife to call 911 and explain to them what is going on, because, of course, he suspects Michael Fossler. And why wouldn't he? She is the only witness standing between him, Michael Fossler, and freedom. If she doesn't testify, he walks scot-free. If she does testify, he risks spending the rest of his life in prison. And we all know that, an ex-cop and an ex-P-file, or not an ex-P-file, sorry, an ex-police officer and a P-file would never survive in prison. It's a death sentence. So Aaron Spencer's thinking the worst, which why wouldn't he? Is he going to unalive her? What's going to happen? What's he doing with her? Well, needless to say, Michael Fossler did re-offend. He raped her that night. And I guess he was going to bring her home, like they went out on a date or something, because when Aaron Spencer was driving down a country road looking for them, this Ford F-150, a white Ford F-150, comes and passes him head on, opposite direction. And he saw his daughter in the passenger seat. And he knows Michael Fossler to drive a white Ford F-150. So Aaron Spencer turns around, follows him, chases him, honks at him, flashes his lights at him, and Michael Fossler won't pull over. So Aaron Spencer performs a pit maneuver and runs him off the road into a telephone pole and into a ditch. Just one second. Sorry about that. My new puppy had a rock, was chewing on this rock, okay? Anyway, so runs Michael Fossler off the road into a ditch. He's yelling at his daughter to get out of the truck, and she's not getting out because Michael Fossler is holding her back. So Aaron Spencer, he has his gun on him in his hand, and he gets out of the truck and he starts walking towards Michael Fossler's pickup. Michael Fossler gets out and starts walking towards him. And Michael Fossler has something in his hand, and Aaron Spencer doesn't know what it is, and he's in fear for he and his daughter's life. So he unloads on him, empties his clip, fires 15 bullets into him. He then calls 911 and tells them that if they don't hurry, he's going to die. And he gives them his location, and he goes home, I guess. I don't know if he stayed around for them or what, but anyway. But now he's being charged with second-degree murder. That is the backstory for what's about to transpire this next week. His trial is set to start on the 26th. Today they have a hearing scheduled. I believe it's a voir dire hearing to see if the judge is going to allow an expert witness to testify on Aaron Spencer's behalf. And don't even get me started on that. If he's not breaking the law, he should be able to put on whatever defense he thinks is, not only the truth, but is going to keep him out of prison. So how can she deny it? But she did, and they filed a motion for her to reconsider. She did, and so she said this was the only day she could have this hearing. And I think that she's just going through the motions to thwart any kind of appeal basis. I don't think she's going to give it to him. I hope I'm wrong, because this expert witness is an ex-FBI psychologist who specializes in grooming, child SA, child grape, and just regular grape, But her specialty is this exact thing. And Judge Elmore put in her denial for this witness to testify that what this witness has to offer has no bearing or impact on this trial. And what? Are you freaking kidding me? Get your head out of your ass and do the right thing. How about that? How about that for once? How about the Commonwealth or the prosecution, the DA, whatever, the state, in some of these trials, how about they just get their head out of their ass and do what they are sworn to do? Is it that hard? If it is, get out of the business. I thought Canton was bad, and people were saying, no, Canton doesn't hold a candle to Arkansas, Lonoke County, Arkansas. And I'm starting to think maybe that's true, but I'm starting to think that everybody's shady. It just is, I don't know, but it's very frustrating, and it makes you nervous because you don't know if this could ever be you. Because I would like to think that if I was faced with the same predicament that Aaron Spencer was faced with, I would like to think that I would do what he did. I think he's a hero. I mean, he was trying to let the case play out in court. He was trying to let the wheels of justice turn, no matter how slow they felt like they were turning. He was willing to do it. He was willing to do it the right way. But then Judge Elmore made that fatal mistake and let him out on $5,000 bond. And ultimately, it's because of her that Aaron Spencer's in this situation. None of this would have happened. Fossler would still be alive, waiting to stand trial for his 43 felony counts. Aaron would be with he's home with his family because he, got bail too, but he wouldn't be looking at spending the rest of his life in prison. He would be doing things with his family, spending time with his family, living his life, running for sheriff, which, in case you don't know, he's thrown his hat into the ring for the sheriff of Lonoke County for this election year. And that's another reason he needs to be found not guilty, because he needs to be acquitted, because they need him for sheriff. They need somebody like him for sheriff. Somebody, and the only reason why he's running is because of the way he's actually seen how the justice system works now, because he's been subjected to it, and he realized that, hey, this isn't quite that great. It's like, it's shit. Don't try to be nice about it. It is shit, this justice system that we have. The Constitution stands for nothing anymore. That's what it seems like. All these prosecutors and DAs and assistant DAs and judges, they're just shitting all over our Constitution and our rights. And we need to put a stop to it. I mean, plain and simple. I'm sure it happens. Well, I'm starting to see that it happens absolutely everywhere. There's nobody, no city or town or county or state is immune to it. It's happening absolutely everywhere. And it's very disheartening to think of what our country, what kind of state our country is going to be in 20 years when our kids are ready to run it. I don't even want to think about it. I don't even want to imagine. It's nothing that I want to be here for. I'll tell you that. So let's take a look at let me see. Make sure I have the right one. We'll start right at the top, I guess. Response to motion or judicial recusal. These must have gotten filed right after I went live yesterday. If I would have rechecked the website, I probably would have before I logged off yesterday. Okay. And here we are, people. Okay, in the circuit court of Lonoke County, Arkansas. Plaintiff, State of Arkansas versus Aaron Spencer, the defendant. Response to motion for judicial recusal. On this day, the court responds to defense counsel motion for judicial recusal. I hate that word. I always sound drunk when I'm saying it. I should just say it and not even think about it, and then maybe I could say it right. 1. Excuse me. Many judges set bonds and see defendants at first appearance in the 23rd District. This judge appreciates the work of all other judges that assist her with setting bonds and doing first appearance. I know where this is going. 2. This judge never saw the deceased. There you have it. She's going to deny being the one to set his bond. Also, this judge did not set the bond of the deceased. There you go. I knew it. Due to discovery in this matter, defense counsel is well aware of these facts. So she's calling the defense counsel liars? Wow, that's professional. 3. Also, defense counsel is well aware that this judge did not sign the affidavit of probable cause for a warrant of arrest for the defendant, Aaron Spencer. In November of 2024, the court saw the defendant so that he might plea, set pretrial and jury trial dates. The courtroom was not closed. Defense counsel may or may not remember the defendant. All counsel and defendant's wife were allowed in the courtroom. Okay, well, that doesn't mean it was open to the public. She's saying that, the defense counsel might not remember, but all these people were allowed in the courtroom. Well, these are people that belong in the courtroom. These are the lawyers, Aaron's wife. That's not public. That doesn't mean it was open to the public. This is an extremely small courtroom. Moreover, other defendants with their loved ones and bondspersons were in the courtroom. There were issues with very limited space, courtroom management, and security. Also, at that time, there were a number of instances of the flu. Therefore, overcrowding was an issue. 5. There has been no favoritism to one party or the other in this matter. Defense counsel within the last couple of months tried to enter motions under seal. The court would not allow said motions to be filed under seal. The public, media, and prosecution all have a right to see those documents. Said documents have never been filed. I can work for 12 hours and not have a problem with my throat or my voice, and then I come on here and it goes to shit. Number 6, this judge is going to do her duty as the presiding judge over all criminal cases to give the defendant and the state of Arkansas a fair trial in this matter. Number 7, the court previously entered an order limiting the number of media representatives and members of the public permitted inside the courtroom during future proceedings. The courtroom does not have unlimited seating, although it is the largest courtroom in the courthouse. After accommodating approximately 100 potential jurors, along with family members of the parties, counsel or record, and counsel staff, remaining space is limited. As a result, approximately 20 additional individuals, including be permitted to enter the courtroom, and such individuals may be required to stand at the rear of the courtroom. As the trial proceeds and jurors are excused or seating becomes available, additional members of the media and public will be permitted entry. These limitations are imposed solely due to space and security constraints and do not constitute a closure of proceedings. Number 8, not only is space an issue in these proceedings, so are management of the courtroom and security are issues. She just keeps going on and on about security. I don't know. There have been many threats against the court and others involved in the trial process. Really? I think that's the first we've heard about this. Number 9, also, due to fire hazards, the courtroom should not be packed with individuals standing or sitting in areas that block the doorway. And didn't she just say people can stand in the back? Yeah, right here. And such individuals may be required to stand at the rear of the courtroom. And now she's saying that it's a fire hazard to have individuals standing. This case should proceed as scheduled, and this judge intends to hear this matter. Therefore, this judge does not recuse in this matter. It is so ordered. Barbara Elmore. She must be left-handed. She writes like a little girl. So that's one down. And it's not looking good. It's not looking good at all. So, okay. State's response to... Might as well let you guys look at this too, right? Okay. State's response to defendant's motion to prohibit the use of prejudicial security measures. Sorry, guys. Okay. State's response to defendant's motion to prohibit the use of prejudicial security measures during trial. Comes now the state of Arkansas by and through John Huggins, Chief Deputy Prosecuting Attorney for the 23rd Judicial District, and for its response to defendant's motion to prohibit the use of prejudicial security measures during trial. Now states, the state admits that enhanced security measures have been implemented by the county and court. However, the state denies that the security measures are unnecessary or highly prejudicial. The state admits that the Lonoke Police Department, Cabot Police Department, and Arkansas State Police graciously allowed officers to assist in courtroom security. Have they ever had to before? Or is this the only case? Because if this is the only case, then that is highly prejudicial. I'm sorry. I don't give a shit what you say. If it's not normal for you to do that, then it's prejudicial. There's no way around it. The state denies that Lonoke County Sheriff's Office deputies performed any security roles. Being that they are public entities, public comments on the court and county offices are an individual's fundamental right. Consequently, this fundamental right should be protected. However, private comments by individuals to various staff members of the Lonoke County Prosecutor's Office, along with Judge Elmore and her staff, have become violent and threatening. Oh, for Christ's sake. And it's all Aaron Spencer's fault, right? He's being blamed for this, if it even happened. Since late 2024, the Arkansas Administrative Office of the Courts, the Lonoke County Circuit Court, 1st Division, and 23rd Judicial District Prosecuting Attorney's Office have been inundated with violent threats from individuals. And you notice how they say since late 2024. Well, October is late in the year, right? Yeah. They're blaming this on Aaron. These individuals have expressed their desire or outright plan for those staff member, along with their children, to be raped, dismembered, or otherwise harmed. And no, I don't agree with that. I mean, if that is happening, then shame on the people that are doing it, because that's not okay. I mean, I said something about Karma getting the district attorney, and I actually ran that into made a run-on sentence, and instead of making two different statements, I said, I hope he doesn't have kids, especially daughters, because I said, I hope you don't have kids or especially daughters. I hope Karma has your number. I didn't mean to make it sound like I was hoping Karma would cause something to happen to his kids or daughters, or I don't even know if he has kids. That's not how I meant it to sound, and that's definitely not what I meant to say. It was supposed to be two separate statements, and I didn't realize that I said it the way I did, or I didn't realize it came out sounding the way it did until I watched it, and I thought, oh shit. So I apologize for that, but because that's wrong. I mean, the family members, the children of these people have nothing to do with anything. In fact, most of these people are just doing their job like they're being asked to. So to even threaten them is unacceptable. This is between Aaron and the state, and because he can't, go after Michael Fossler anymore. But so if that is happening, then I that's terrible, and it's embarrassing that it's come to that, because we don't want to be those type of protesters. We just want the corruption to stop, and we want the good people in the community to be left alone and to live their lives and you know, you get all these lowlifes that get arrested for something, and they're out on bond, or they, get or they get their charges dropped, or they get chance after chance after chance, and then you have an veteran who is a farmer that hasn't broken the law in his life, has no record, and he's protecting his family, mainly his daughter and himself, and now he's being charged with second-degree murder, and they are bound and determined to convict him of it. I don't get it. Same with Karen Reed. She doesn't have a record. She's never been in trouble in her life. And they were so hell-bent on convicting her of murder or manslaughter. And it's like, and this is going on while known felons are acting like prison is a resort and there's a revolving door and they come and go as the judge sees fit, but most of the time the judge doesn't see fit. They let them off with another chance. And it's disgusting. It's heartbreaking. It's makes anybody that follows the law and respects the law, makes them afraid to even be around the law, because we're, in their eyes, we're no different than the lowlifes that have rap sheets a mile long. I don't get it. I don't get it. So there's that. In December of 2020, called the prosecuting attorney's office 5 times, telling office staff he was going to kidnap their children and make them watch as he, oh my God. Now this is just not okay. Where's my cursor? As he raped and murked them. Well, how come this is the first time this has ever come up? That's strange, isn't it? They weren't going to mention it until he asked for her to recuse herself, or until he complained about the amount of security. If it's been going on since December of 2024, where was the security up until now? Did he say he was only going to do it during the trial? I have questions. Those threats were immediately reported to law enforcement for investigation. The prosecuting attorney's website has received submissions encouraging prosecutor Chuck Graham to commit S. And messages stating, quote, "I wish you the exact day this predator got and deserved," end quote, on December 27, 2024. Quote, "I hope you all enjoyed dying slow and painful deaths like you deserve," end quote. On January 12th, 2025, he said, quote, should put a few holes in his head," end quote, on January 13th, 2025. And, quote, "the world will be a better place when you're all in hell," end quote, on July 24th, 2025. Well, they have quotes, so it must have been said, but that doesn't mean why should Aaron Spencer be held again, responsible for that? Why is he paying for that? On August 2nd, they've already convicted him. On August 22nd, 2025, an individual left a message for Mr. Graham on the website submission form with the name, Jesus Christ, quote, "Grape Judge Elmore," end quote, and contact email address listed as, quote, "fuck you at freeaaronspencer.com," end quote. Wrote the following. And I'm sure Aaron Spencer's not happy about this either, because he's just not like that. He's not that type of guy. I'm sure this disgusts him just as much as it does us. "I will come to Grape," oh my God, "Barbara Elmore, her loved ones, her siblings, her children, and her co-workers. I will grape her like her buddy Fosler raped Spencer's child. I will, oh my God, grape you too, you smarmy fucking faggot. This is a quote. This is not me saying this. See how you feel about it. Oh my God, this is terrible. I will grape your wife, your kids, and your loved ones. I will grape, dismember, and burn your corpses, you pedophilic cunts. I hope you'll meet that fat rapist in hell, you swine. End quote. It's disgusting. It is. It's disgusting. I better make it thicker because, or darker because, yeah, it's pretty bad. On August 9th, on August 19th, 2025, the chief of police for the Arkansas Supreme Court contacted the court reporting a concerning email they received regarding Judge Elmore. This email was sent by an individual who indicated he planned on making a trip to see what the clown judge, quote unquote, looks like. The supporter closed the message, quote unquote, see you soon. These examples are merely a small sampling of the nearly daily occurrences that have created a substantial security risk to all individuals involved. The Lonoke County Courthouse campus contains several fully staffed county offices, as well as 2 other judicial divisions. Officials within Lonoke County, including this court, have a duty to protect staff members and the general public that frequent their offices. However, and most importantly, the court must ensure Lonoke County jurors are not harmed by bystanders in the event decides to act on their threats of harm while performing their vital civic duty. This must be the court's utmost priority. Isn't it supposed to be utmost? I'm not positive, but the state believes, based on the foregoing threats, some of which have been brought to the state's attention by other judicial offices, heightened security measures are necessary for the safety of the defendant and his family, defendant counsel and staff, county staff, and jurors in the commission of their duty. The state has no objection to the defense requesting the court to inform jurors, once seated, that the heightened security present should not be taken as any indication of security concerns regarding the defendant, but as a protection measure. Respectfully submitted, John Huggins. Now, the only thing about doing that is if you make a point of saying that, that's only going to draw attention to it. So now you're going to put it in their minds that, oh, I never even thought about that. Why would they say that? Maybe the extra security is because he's dangerous. I don't agree with that. I don't think it should be done that way. I think that will be just as prejudicial as the security, the heightened security, to be honest with you. That's just my opinion, for what it's worth. Okay, so let's see what's next. Whoops. There we go. Okay. Joint motion for orders regarding scheduling and motion for the continuance of pretrial and trial. No, I don't want to read that. Reply to clarify the record in response to court's response to motion for judicial recusal. Wait a minute. Okay. Because I know Casanelli responded. So, responded to the judge's response. So I just want to make sure that Okay. Replied to clarify the record in response to court's response to motion for judicial recusal. The defendant, Aaron Spencer, through his attorneys, states in reply to the court's order regarding its recusal. The court does not address most of the issues presented in the recusal motion. She's just going to start right off the bat. Counsel addressed the bond matter in the motion for recusal, and the court appears to agree that it was set by the circuit court, although apparently not her personally. Despite all reasonable efforts to confirm that information, defense counsel became aware of this after the Supreme Court's decision on the earlier writ, as outlined in the motion, under circumstances that create other issues of concern. As pertaining to the closed arraignment, lack of space for the public was not at issue. There were empty benches in the courtroom at arraignment with plenty of space for members of the public and the press. The courtroom was not even half full when Mr. Spencer appeared before the court, which was more than sufficient space for the members of the public who were made to wait outside. As the record of that proceeding confirms, the court made no remark at arraignment related to the size of the courtroom or overcrowding in response to defense counsel's objection to the closure. The court counsel was required to identify the defendant's family and other than counsel, only they were permitted inside the courtroom. That didn't make sense at all. Arraignment was conducted on December 2, 2024. There was also no flu epidemic at that time. In fact, it was a normal year for the flu. CDC data shows that Arkansas had minimal flu activity at the end of November of 2024, which was 2 days before the Monday hearing. She went to the CDC website and checked the judge's story. That is crazy. That's awesome. That is fucking awesome. No other flu-related precautions were taken, such as masks or... Oh, now she's back at the court. No other flu-related Let me start that over. No other flu-related precautions were taken, such as masks or distance requirements. She means in the courtroom by the judge. The documents requested to be filed under seal were properly subject to sealing under the law and logic. The court's order indicated that no documents would be filed under seal, not that there was no legitimate reason that those specific documents should not be sealed for the reasons explained in the motion. As to the court's restrictions on the public's attendance at trial, the court appears to suggest that it will permit the courtroom to fill to capacity. However, that is not what the court's prior order outlines. Given the amount of space and available seating, the courtroom will not be close to full with 55 people, including parties, counsel, and family permitted to attend during the trial. The number permits about 20 to 25 members of the public to attend, in addition to the parties, counsel, and family. The court required the parties to identify. At pretrial, the court reserved seats for family and counsel staff, so those seats were not available, even if empty. There is no need for attendees to stand or sit in areas that block the doorway for the public to be permitted to fill the empty seats in the courtroom. The gallery alone contains 75 seats, not including seats along the walls of the courtroom, counsel tables, or a separate conference table that sits empty for the most part. The courtroom also has extended empty space that could serve as seating without blocking any other area. Further, there are other methods by which the court can ensure public access that have not been considered. There is no record of any threats. There you go. There you have it. There's no record of any threats made to the court or parties. The court has never mentioned this to defense counsel. Spencer has nothing to do with any threats and has not been made aware of any threats. If there have been threats made to the court, it would be unnecessary for security measures to target Spencer during the trial, as the potential danger would be elsewhere. If the court suggests there is a need for the overabundance of security, as was at pretrial, an adequate record should be made on the issue, along with a balancing of Spencer's constitutional concerns and a narrowly tailored plan to ensure safety, with the parties given the opportunity to address any issues on the record. The court denied the motion to recuse without conducting the requested hearing. As such, the defendant files this pleading to ensure the record is clear on these points in the event there is further review of this court's refusal to recuse from this matter, meaning should we decide to appeal. She's not playing. She's fucking pissed, and I don't blame her. You know, I mean, this Judge Elmore thinks that she's just so sly, and Aaron Casanelli has her fucking number. That's all I can say. She has her fucking number, and I'm here for it. To state's response to the defendant's motion to prohibit the use of prejudicial security measures at trial. This is crazy. They're just going to keep going back and forth until the trial starts, I think. That's what it seems like. That's what it seems like. And I'll be here for it. Okay, reply to state's response to defendant's motion to prohibit the use of prejudicial security measures at trial. The defendant, Aaron Spencer, by and through his attorney, states for his reply. The Lonoke County Sheriff's Office was observed outside the courthouse, on parking lots, and nearby streets. Whether orchestrated or not, it added to the overwhelming presence described in the defendant's motion. Until now, no one, not the court, not the state, has given Spencer or his counsel any information about threatening communications, much less discussed with them what security measures might be appropriate while also not impairing Spencer's constitutional rights. And this information was only forthcoming after defense counsel lodged a formal objection to the excessive display at the pretrial hearing. The court's January 22, 2026 order denying recusal, and later the same day the state's response to the defendant's motion to prohibit prejudicial security measures at trial are the first time there has been any formal communication or court record of information regarding threats related to this case. And those are only references in pleadings. Although the deputy prosecuting attorney informally mentioned the day prior, January 21, 2026, after the defense's filings on this point, on a call with defense counsel that his office had received hostile communications, counsel for the state and defense both acknowledged the unfortunate reality that this is not unusual for participants in the criminal justice system. Both counsel have experienced this many times before. Okay, so what's the big deal? The state's response contains assertions but provides no evidence regarding these threats that might support findings pertaining to security risks, and does not provide details that might provide insight as to the realistic security needs. Yeah, how come they didn't attach the emails and the messages that they received? Why aren't those being shown as an exhibit? That's odd. Numerous of the quoted threats to Chuck Graham, as written in the pleading, do not appear to relate directly to this case. So, what? Let me read that again. Numerous of the quoted threats to Chuck Graham, as written in the pleading, do not appear to relate directly to this case, or could relate to numerous cases the prosecutor's office is pursuing. Okay, well, I have one question then. Is this beefed up security going to be present at all of these cases? At all of these hearings? For all of these trials? Or for all of these cases? Or just Spencer's? I'd be interested. I hope somebody sticks around for at least one or two of these other cases to see if the beefed up security is still a necessity. And then we'll know. As of the filing of this reply, the defense still has not been provided anything tangible related to those purported threats. Well, what are you expecting to be provided to you? You have emails, don't you? You said you did. Don't you have a tech squad or anything that can track down the email's IP address or anything? I mean, this is 2026, right? I mean, what the fuck? And why weren't those threats handed over to the FBI? If you work for the state, and the court is definitely the state, that's a federal crime, right? To threaten a judge. So why haven't these threats been turned over to the FBI? Okay. The state's response does, however, confirm that counsel for the state and the court are aware of the communications directed at the other. It seems apparent that these communications have been the subject of prior discussions between the state and the court without any mention of this, much less inclusion of Spencer's counsel in these discussions. Well, whoa. The state and the court shouldn't be meeting without Spencer's counsel. That's ex parte, right? Isn't that an ex parte meeting? Even if it's not about the fucking case, but this is, because it's in regards to the case, they're not allowed to meet. That's ex parte communication. Wow. These are case-related discussions that resulted in the court's actions in the case that negatively impact Spencer. Yet his counsel have been excluded from any discussion or notice concerning the communications or security measures. Spencer and his counsel would agree to reasonable security measures for the protection of all participants. However, the court's decision to employ an alarmingly excessive law enforcement presence at the pretrial hearing without discussing the need and impacts of doing so with counsel for the state and counsel for the defendant is troubling. Spencer is entitled to an opportunity to address the impacts of the heightened security measures on his rights and for there to be a formal court record of the necessity, tailoring, and balancing of constitutional concerns related to the security measures to be employed. It is also concerning that the court felt there was a reason to engage such a display of force without notifying the defense, suggesting and giving the appearance that perhaps the court has allowed these communications to influence its perception of the defendant. Yeah, to justify them feeling that he's guilty, to make them feel better about going through with this trial. If they make it look like he's a dangerous man and that he's communicates or associates with people the type of people that would make these kind of threats and the type of people that would possibly follow through with them, then we, no wonder we think he's guilty, and no wonder we're going through with this case against him. It's shit. It's pure shit. Wherefore, the defendant, Aaron Spencer, asks the court to grant the defendant's motion in limine and for any other relief the court finds appropriate. Respectfully submitted, Aaron Casanelli. She's not fucking around. She's not happy. And I can't say as I blame her. I mean, her client's getting fucked over, right? There's no other way to look at it. Let's see this active one. Because I think I found some filings on that one time. They keep going back and forth between the open case and the active case. Just one second. Because this one's from today, 5:30 this morning, so. Motion to, sorry. My bad, got a little ahead of myself. Motion to supplement the record with pleadings filed since petition for writ of certiorari was filed on January 16, 2026. Comes now the petitioner, Aaron Spencer, by and through his attorney, Michael Kiel Kaiser of Lassiter and Casanelli, and for his motion to supplement the record states, 1. Spencer filed a petition for writ of certiorari in the above case on January 16, 2026. 2. Since that time, numerous additional pleadings have been filed in the underlying case in the Lonoke County Circuit Court, case number 43CR-24-551, that are relevant to the court's consideration of the petition. 3. Consequently, Spencer seeks to supplement the record with the pleadings that have been filed in the circuit court since the petition was filed on January 16th, 2026, as they are essential to ruling on the petition. 4. These additional pleadings are material. As such, Spencer requests that this court direct that the supplemental record be filed. Wherefore, the petitioner, Aaron Spencer, respectfully requests this court to direct the clerk to lodge the supplemental record of pleadings filed since his petition for writ of certiorari was filed on January 16th, 2026, and for any proper relief to which he may be entitled. So, that is it for now, you guys. So, we'll keep our eyes and ears peeled for more, but she's making him work for every little bit, and she's not given much. So I will be waiting to hear the results of the hearing. I don't know what time it was supposed to be held today, but they're 3 hours ahead of us, I believe, so it might be over already. I don't know. I haven't been on YouTube since I got home to see if Defense Diaries has any news or updates. So as soon as I hear something, I will be sure to drop a video or a short, or go live and keep you all posted, okay? So until then, I hope you guys all have a good rest of your day. And stay safe, stay warm, stay dry, stay happy. And keep your prayers and thoughts on the Spencer family. They need it. They definitely need it. All right. Don't forget to like and subscribe. It's free. And I'll see you all later. Bye.